Okay, here we are again. Happy holidays, everybody. I'm joined by uh, two of our lawyers, Stu de Haan and Matt Kezhaya, and also by Mortimer from our Iowa congregation, because our topic tonight is Iowa. And we had a couple of denials for our participation in
Okay,
a public
here we are
forum in
again.
Iowa the past
Happy
couple of
holidays,
years.
everybody.
I'm
And
joined
that's
by
progressed into
two of our lawyers
claims.
against the state. It's not litigation yet, but there is an Office of Civil Rights in Iowa that needs to be proceeded through first. And recently, that office declared in our favor, as we see it, uh, regarding our complaint from 2024, when Iowa refused to allow our congregation to host an event on the Capitol grounds, on the grounds that they said it was going to be harmful to children. And the Iowa Office of Civil Rights declared that this was worthy of further investigation. Further investigation is warranted in this case. To get more specific about the details of what happened leading up to this, it was in June of 2025 that the ACLU of Iowa filed the complaint with the Iowa Office of Civil Rights on behalf of the Satanic Temple, alleging that TST had been discriminated against as a religious minority by the Iowa Department of Administrative Services through its then director, Adam Steen, and by the Office of the Governor, with whom Steen colluded in crafting a denial of public accommodation, rejecting the Satanic Temple of Iowa's uh, presence on state capitol grounds in December of 2024. Steen had previously approved a holiday display by TST in the Capitol Rotunda in 2023, but he's now congratulating himself about the pretext he offered to cancel the event in 2024. He said that because the event was going to include a Krampus costume party that would take place at this event, and as the mythical Krampus was said to have administered corporal punishment to children, naughty children who didn't deserve gifts or whatever, then they could reasonably believe that we intended to beat children on the public grounds during this event. And therefore, in the name of children's safety, the event was denied. And this already is kind of a bizarre excuse. It seems very clearly to be pretext already to just keep out a non-preferred viewpoint from the public square. But it gets even worse because we weren't offered any opportunity to amend the event. I think, Mortimer, correct me if I'm wrong, but it was even offered that the Krampus costume party would be taken out of the event if that was really a concern. And they never replied. They just stuck by the denial. And now, this whole denial, this whole issue of denying the Satanic Temple presence on the Capitol grounds. And again, we had a display in the Capitol Rotunda in 2023, and this sparked national controversy, and it resulted ultimately in a failed congressional candidate from Missouri driving over to Iowa and smashing the display. And he oscillated between playing the weepy victim role when it turned out he was actually going to be prosecuted for that as a crime, and also trying to position himself as this hard-ass warrior in defense of Christian values. And this played out for a while as well. And disappointingly, he generated quite a bit of support playing his weepy role as the victim and gained over $134,000, I believe it was, towards his defense fund, which probably didn't cost that much, and has desperately tried to push himself forward as a conservative influencer since then. But we were going to talk about the ramifications of the warranted further investigation as deemed appropriate by the Iowa Office of Civil Rights, and what the implications of that are and what the next steps are. And I know that this kind of falls outside uh, your jurisdiction, so to speak, as lawyers, Stu and Matt, what goes on with offices of civil rights. And I know Massachusetts has a similar thing. We've gone through that before where we had a discrimination complaint and had to go through a discrimination office that was set up specifically by the state for those purposes in Massachusetts before it goes into litigation. And we have the ACLU working with us, and I believe the will is there to litigate, but this is part of that process if it comes to that. And I wanted to get some kind of insight into how that process works for listeners filing these complaints, what process that takes, what they hope to achieve by having the complaint first be filtered through an Office of Civil Rights, and then the potential for litigation following that. And I'm not sure who would prefer to take that more. If I understand correctly, Matt has a better grasp of working with civil rights offices. Am I correct in that, Matt?
Yeah, I've done some research on how the Iowa one works specifically. So, as I understand it, it's a two stage process before it gets to the part where you can properly call it litigation. We've passed stage one, which is basically you've stated a claim. We got a very robust decision within the past month or so that basically goes through the allegations of our complaint. This is what the other side says, although we didn't have an opportunity to review what they said and issue responses. And the long and short of it is it comes down to, is this a pretext? And there's probable cause to say yes, so it moves on to stage two, which is where a investigator for it's the IOCR, Iowa Office of Civil Rights, um, basically does an investigation for us. So it's kind of nice in that an investigator is the one asking the questions. So the other side's opportunity to say no is much more constrained. Whereas, for example, in civil litigation, if you issue what's called written discovery, you'll just get a sea of words that basically amount to I ain't giving you shit. So it is nice to have it in the administrative process for that reason. Um, and basically, the long and short of it is they perform a more detailed factual investigation than what information they have on hand to determine whether there's probable cause to say functionally, yes, it's a pretext, at which point it goes before an admin judge, which is distinct from your normal Article 3 judges, which is to say the judiciary that you're used to. Admin judges are state employees. They're employees of typically that particular agency, but I've also seen other states they're just admin judges. That's they hear all kinds of stuff, whether it's a nursing license revocation proceeding or a utility issue or whatever other kinds of licensure issues, or in our particular case, a public accommodations problem. So that's kind of the very brief rundown of what we're looking at in terms of timeline. I understand that this is probably going to take like 2 years, which is cause for concern on our part because we only have 2 year statute of limitations. So if we want to proceed in federal court, we have approximately 1 year to file that claim. Otherwise, we don't have a Section 1983 claim anymore. That's stale and gone. So we kind of have a decision to make, and that's being discussed by the attorneys behind the scenes, whether we want to drop out of this admin process and proceed in federal court, or whether we want to basically see what happens in the federal process, or rather the admin process. Technically, we don't have to make that decision for, again, about a year, but for me personally, I'd rather not see them get very in depth with the investigation, only to see us kind of yank it out from under them. I think it's kind of a dick move on the one hand. On the other hand, we might get very useful admissions, very useful information that we can use against them come federal time. So that's a developing matter.
Well, as it stands, the investigation, the initial investigation report we've gotten back from the Iowa Civil Rights Office is very much in our favor, and they state outright that we've made a great prima facie case that, given the facts, unless they're contested or nullified in some way, uh, show that we were discriminated against. And I feel it's worth mentioning that the discrimination that we actually file a case against is just part of it. The crazy things I see coming out of Iowa and the independent press there and the bizarre conservative network they have going on really is is quite fixated with us. And there was even an effort, this must be recalled, I think in 2023 or 2024, there was an actual effort to pass legislation to ban Satanism from public places, which would have had all kinds of difficult ramifications for us. But maybe you can give us a sense of what that environment is like, that kind of social atmosphere in Iowa, Mortimer. Do you get a lot of angry outreach when you guys do events? Do you have people showing up, shouting and causing a scene? Or for the most part, have they kept confined to being online and trying to pass legislation to actually silence our voices?
We do face a lot of online hate. We also, when we do engage in the public, like our Paradise Lost reading marathon, we had people driving around the block blaring Christian music, screaming at us. Uh, we have had, I mean, people calling my place of business trying to get me fired. A lot of stuff like that has happened to multiple people in our community. Yeah. We've also had a lot of people who support us wholeheartedly in all that we're doing. We were just putting up flyers for an event earlier today, and they're like, "Oh, you're the Satanic Temple? Yes, let me take 3 flyers." So equal amount
Well,
of
it's very
support.
polarizing then.
Yes, like an equal amount of condemnation and support, which is how this has sort of been since 2023 when we were launched into the stratosphere.
Yeah, yeah. And again, that was due to a guy coming and beheading your Baphomet statue or display that you had on the grounds and then smashing it on the ground. But another eerie thing about that was the expectation of universal applause that seemed to be implicit in his behavior after that. He seemed absolutely gobsmacked that there were any charges against him or that there might be any negative repercussions. Like I said, he immediately devolved into the crying victim mode as soon as the going got rough. But I mean, he needn't have worried too much. They eventually let him charge to a third degree criminal mischief charge, something like that. Something that's probably expunged from his record by now, and he kind of pleaded out. And it's difficult to imagine that that would have ever been an option to a Satanist uh, who might have done similarly to a nativity scene or something of that nature. But that's
Especially to brag about it to the press.
oh yeah, yeah, and brag about it constantly. And in that vein, you see Adam Steen, who penned the denial, is now bragging very much. It's his whole campaign. It's his whole gubernatorial campaign. He's running to be governor on the ticket as the GOP candidate without any recognition, it seems, of the fact that the things he says outside of the courtroom or outside of the paperwork trying to justify denying us in 2024 can still be used against him in the court of law. And he's fashioning himself as Jesus guy. And in a press conference, he answered a question about non-Christian displays by saying that he would deny anything that doesn't put God first, which I would hope people would have some understanding of what an egregious and extreme violation that is of fundamental liberties, whether you agree with the religious viewpoint in question or not, to have some kind of government flunky like Adam Steen telling people that they cannot identify in this way or that they're going to be treated as second-class citizens if they do, is ceding some authority to the government that they've never really had in the United States, in the modern era. And so it's very alarming and disconcerting. But one of the funny parts about the Iowa Civil Rights Office report was that we got to see the defensive replies of both the governor's office and of Adam Steen's office. And I'm not sure that we had that before. Maybe we did, but it was the first time, at least that I learned, that the governor's office was claiming that they had nothing to do with it and that Steen's office took total control over approvals of and denials of events on the Capitol grounds. uh, apparently not aware that through Freedom of Information Act request, we had obtained text messages between the governor's office and Steen where they were talking about having a conversation about the request made by the Satanic Temple and how it was going to be handled. And I think that's all we got from that, but that was enough for, even the Iowa Office of Civil Rights to declare that there was reason to believe that the governor's office had colluded and could still be named as a defendant or whatever you want to call it when it's in this stage of the process. How strong do we think that case is against the governor's office if that's the only thing it hinges on?
I feel like it's really going to depend on what those communications were between the office of the governor and Steen's office. I mean,
We're missing a lot more communications, aren't we?
yeah. So the someone who's represented by the ACLU right now on a FOIA cause of action issued a FOIA request asking for all the documents. And they got substantially none because the governor's office is invoking what it is essentially made up called executive privilege, which says if I don't have to give you, if I don't want to, I don't have to give it to you, which is just not statutorily permissible and very inconsistent with all kinds of FOIA law. So ACLU is suing out that claim separate from us. So hopefully we'll get some stuff through that, or hopefully the investigator, or if not the investigator, potentially admin, judge, or federal court, depending on what venue we're going to be in, will be able to get it. But as it stands, if they're going to assert executive privilege and we don't get to see it, well, then it's going to be very hard for us to prove it's protectual, other than what we already have, which is they met with it shortly beforehand. And I think the governor's office passed the press release to them, or whatever stock language they use, to the governor's office for approval. So maybe, I mean, it's going to come down to pretext, I think.
In Mortimer, tell me what the situation was for this year. If I understand correctly, your congregation had something on the calendar for the Capitol again this year, and then it was again denied and taken off. And, I was seeing that at the time where I'm also seeing this investigative report from the Civil Rights Office where the challenge is this claim that we were going to beat children while dressed as Krampus based on nothing at all but the old legends of Krampus. And I was wondering, I don't even know what was the pretext on this year's event. What was the reason? Who signed that denial this time?
There is a new person in the role that Adam Steen had because he dropped out of his role as Director of Administrative Services so that he could run governor. And we filed pretty much the same exact event proposal as we did in 2024, just to see if we could get it on the books this year. We were added to the events calendar, and we weren't really given much of a reason why we were denied other than the same reason as last year. I actually found out that we were denied from Adam Steen's press conference. I hadn't checked my email. He apparently was denied 2 minutes. He was informed of the denial 2 minutes after I'd gotten the email saying that we were denied.
Okay,
But
so he was probably directly in contact with whomever had penned that denial. But in the event, were you also offering to do a Krampus costume party?
yes, we were, because we didn't want to insinuate that there was any beating of children going to be happening, even if we did a Krampus costume contest. If they had asked us to take it out, I would have done it.
So you felt that taking it out preemptively was legitimizing the concern.
Yes, exactly.
Do you think that's best strategy, Matt and Stu?
Yeah, I think so. The the risk of basically a waiver or legitimizing the concern, I think, was greater than not. Also, it's curious to see whether we're going to get a different answer this year before or after the complaint. So it did scare out some information that or rather force out some information that I don't think we otherwise would have. What do you
Yeah,
think?
and also I also think that it's kind of playing nice, right? So they're like, well, they made this assertion, well, because of this one thing, we're not going to allow it. So, you have to make a decision on that. And I think this is the funniest pretext of anything we've dealt with. We're no stranger to pretextual denials, right? I mean, that's what happened in Scottsdale with the pretext being we weren't from the proper jurisdiction to be giving a talk. It's like, okay, from a reasonable person's standpoint, you can at least logically make that argument. But this is the equivalent of like, if you're having a Santa Claus costume, oh, we can't have that because you're encouraging criminal trespass down people's chimneys. I mean, the absurdity is so strong. Or, if it's the tooth fairy, you're engaging in illegal commerce with minors. It's as pretextual as you can possibly get. So then the question becomes like, how do we deal with something so, so clearly with the intent of violating our rights? But we're in a regime right now where that's all the rage. It's very popular to violate rights, whether you're an immigrant, whether you're in the LGBT community. It doesn't matter. It's in vogue. Like having rights, like constitutional rights, are considered woke now, and trampling people that are not in the dominant narrative is considered patriotic. These things have gotten so un-American that the cognitive dissonance is so strong, that it is kind of hard
religious
to
liberty has become, and by this perspective, religious liberty has become stomping out our voices so theirs can be primary because they have the religious liberty to have exclusive access to public spaces.
That's always what it's been. And I mean, part of the reason I got involved in this so many years ago was that I realized at a young age, like before I was an attorney, that every time that there is a religious liberty law that's enacted, what it's doing is essentially taking away someone's rights, because all the religious liberty that matters to them, the only liberty is the freedom to stomp out any opposing voice. They have the liberty to do that. That's the only way they see this. It's always been about Christian supremacy, and it's never been about actual religious liberty. It's the liberty to oppress. Again, it's cognitive dissonance, but it's been this way for quite a while. Of course, we're just on the front lines of this, but this particular pretext is particularly comical to me.
And it has to be said that the Iowa Office of Civil Rights, unambiguously indicated that they're not really buying into the governor's office and the Department of Administrative Services claims that this was a legitimate pretext to prevent us from having this event. According to the report, it was addressing the responses it got from the governor's office and the DAS, the Department of Administrative Affairs, which is where Adam Steen was placed and gave him the ability to deny the event. The report said, respondent DAS asserts that it denied complainant's application due to concerns about violence against children. DAS states that the complainants provided photos of examples of Krampus costumes, which include birch branches. Respondent cites several articles about violence during Krampus runs and asserts that birch rods, included in the typical Krampus costume, are associated with a tradition of hitting children. And then it goes on and says that, this was their first line of defense, that we're going to beat children, we're going to dress as Krampus, and then we can't help but beat children when we're in Krampus mode. And then respondent further asserts that it denied 4 other applications for events to use Capitol space on December 14th, 2024 by groups that are not associated with TST or Satanism. But then the Office of Civil Rights goes on to add some exposition that they might not have needed to, but I appreciate that they did. It says, each of those applications was denied because the application was received less than 30 days before the event. So it is not clear that these are relevant comparators, because the stated reasons for denying the event is not similar to the reason for denying complainant's event. And somewhere along the line, they too pointed out that they gave no opportunity for us to assure that we wouldn't beat children or give us the opportunity to amend it to take out the Krampus event or any such thing. They just gave a denial and they stood by it and they said that's good enough. And this is going to apparently apply in perpetuity to keep Satanism out of public spaces.
I love that they did this. I love that they did that because there's such a stark difference between saying these people irresponsibly blew a deadline versus we're stopping them because they have the wrong belief. I mean, it bolsters the argument that we have.
It's still a state agency, though. I don't know where the personnel of the Iowa Office of Civil Rights might be tied up in other politics in Iowa. Is there any concern about that? Is there any concern that they'll actually try to run out the clock on statute of limitations? It sounds like Matt's saying that we would be able to move into federal court anyways if we're butting up against that timeline. But do we worry that the Iowa Office of Civil Rights, despite this report, might not have the neutrality we seek?
It's always a concern. We've gotten some very favorable looking orders on motion to dismiss, only to turn around and lose for the exact same reasons why the judge said that's not grounds for dismissal at the pleading stage. So, at the end of the day, we're talking about literal government attorneys. These are political offices. I say government attorneys, these judicial positions, which, by the way, who's to say we're even going to be getting in front of the ALJ, the admin law judge, in time for us to even make an informed decision as to whether we want to proceed in federal court. But it's true everywhere. It doesn't matter if we're in federal court, state court, or admin court. At the end of the day, judges are just people, and they're susceptible to the same biases that afflict, for example, Steen.
Do you think that Steen has painted himself into a corner, making his whole gubernatorial campaign about denying the Satanic Temple, and now seeing that the Office of Civil Rights is saying that further investigation is warranted? Don't you think any lawyer would be telling him to shut the fuck up and that he's just mouthing off about this? And at this point, and this is what I mean about painting himself into a corner, where is he even going to go? I don't even think he has the mental capacity to talk about real issues. And this is what he's hinged his whole identity on at this point. And if anybody's telling him to shut up, I think he might feel like he's just abandoning his run for governor. I know this is really speculative, but I just wonder sometimes where somebody like this is coming from.
Well, this is the national zeitgeist, though. I mean, we've got an entire administration that's aggressively incompetent. It's their might is to be hypocritical, incompetent, just as base as possible. Like they don't care about the rule of law. They don't care about public institutions, and they've been slandering the courts in so many different ways in so many different kinds of cases, saying that basically there's a conspiracy theory that the courts, this concept of activist judges in any court that grants someone the civil rights that they're entitled to by the Constitution is deemed some kind of evil entity. I mean, this is the world we're living in, and I think he's just going through that exact ignorant grievance playbook that goes all the way to the top. So I think these are popular positions. I don't think that's going to last forever. I think the rats are eventually all going to try to flee the ship when reasonable minds come back. But at this moment, all the adults have left the building, and I think he's banking on that really popular ignorance and arrogance that has brought this regime, has gelled it basically. I think it's just the zeitgeist.
Well, we can hope it backfires, but I think it's disconcerting that he so easily hijacked the entire GOP gubernatorial dialogue that all the rest of them now are just talking about how anti-Satanist they'll also be. So what do you think, Mortimer? Does this win elections in Iowa?
Well, honestly, I don't know. But it seems like Adam Steen is getting a lot of heat from people who are actively anti-Satanist because he originally approved our 2023 display.
Right, and this actually draws attention to that. One of his competitors for the GOP candidacy put out a press release just to make that point, just saying, well, of course, Steen was the guy who approved them in 2023 with the Baphomet that ended up getting destroyed by the guy from Mississippi. So it was a bizarre tact for him to take. But sorry, continue.
Yeah, I mean, in the comment sections, I'm constantly seeing when Adam Steen is condemning us, he's also getting flack from people who think he should have taken it farther. I don't know that this is a winning strategy because I don't know how much people actually care about us. I don't think we're that big of a deal. I mean, I care about us, but are we that important to the zeitgeist of Iowa that you want to run a campaign targeting this specific outgroup? It just seems
I
alienating.
don't think it's hyperbolic to frame it as, are you willing to dispose of our First Amendment fundamental liberties because you're offended by a satanic display in a public space? Like
I mean,
I don't think it's anything short of that.
Yeah.
I think this goes back to the entire concept of fighting evildoers. Like it's such a base level, like who doesn't hate evil? You hate evil, I hate evil. Look, we're the same. And this bullshit has worked for a decade now. But you can only run policy on grievance alone for so long. Eventually, it peters out for exactly the reason Mortimer is saying is like there's real problems with the people of Iowa, economic problems, social problems. There's issues in every state, education problems, and you're focusing on this. It can't last. I mean, this is a bullshit made up problem, but bullshit made up problems are what they've all run on for so long. And I think this is going to spectacularly backfire. I just hope it's sooner than we think.
I hope so too, because you'd hope people would realize that we have nothing to do with their grocery bills, with inflation, with problems in the educational system, any of that. And in fact, we're just an indication, the outrage against us, of how education has failed. I think when people don't even understand that you don't pull something out from under people like freedom of religion, freedom of speech, without a whole plethora of problems resulting from that, and us fundamentally not being the same country we were before when you allow those things. And I feel like it looks to me like in Iowa, you have a lot of politicians who have no idea what they're doing from the governor on down. I mean, when you have the governor claiming this kind of executive privilege to conceal documents, and yeah, I don't think we're part of that lawsuit, but I think we're part of the evidence in that lawsuit. Am I right about that? Like, I know there's a lawsuit playing out about the Freedom of Information Act requests that the governor's office has refused to honor in the name of executive privilege. Or
it's the Iowa Atheists and Freethinkers who filed that FOIA request, and that's their lawsuit. But it is specifically about documents concealed during the 2023 holiday season about the Satanic Temple.
Okay, so
not 2024. 2023 is when the display was destroyed. 2024 is when the event was denied.
It was 2024. Yes, thank you.
Okay.
So they're working hard to conceal these documents, which would lead one to think that there's something worth hiding. I don't know what to think about that. Do we really think there's something worse than just losing this case, or is that bad enough? Like, it seems like an extreme step to take for the governor to make up new rules about freedom of information out of the blue, unless it seems like it's particularly catastrophic to release these documents. But is it a huge loss for the governor's office if they're found to be in collusion with somebody who wrongfully discriminated against a religious minority? I would like to think that would be a severe hit to take, but I'm also not exactly convinced that it wouldn't be something they could brush off. But the refusal to give up the Freedom of Information Act request documents would indicate that there is some fear of that happening.
I think I think there's a credible claim to be made on that front, but I do know that this executive privilege argument is not limited to us. They raised it in other FOIA cases too. So I think that lawsuit is about more, that particular lawsuit by that particular group may be just about us, but I understand the issue is more broadly stated. So there might be other litigation that I'm unfamiliar with.
Is there a real effort to expand that type of executive privilege, or do you think this is just kind of a pretext that people fall upon when they find themselves in this situation? Because it should be noted that when we were deposing a senator in Arkansas regarding uh, our effort to put up the Baphomet Monument, where they put up a Ten Commandments monument on the Capitol grounds, he was also claiming executive privilege on all kinds of things where it was questionable at best whether that was a thing at all. Do you have a sense that there's some kind of movement among the theocrats to also expand executive privilege in this way? Or do you think that's just the only semi-plausible line of defense once you're backed into a corner on Freedom of Information Act requests or questions you don't want to answer as a public official?
So FOIA is different from what we were dealing with in Arkansas. In Arkansas, they were refusing to answer questions in a deposition, which you only have the one option. You have to say it's privileged. And his claim of privilege wasn't executive privilege; it was speech and debate clause privilege, which had merit. Whether or not it's right, I don't know, but we chose not to pick the fight anyway. This is different with a FOIA case. FOIA, you have statutory carve-outs that essentially say all public records are presumptively to be turned over, and then here's a litany of exceptions, except if it's one of these things. Executive privilege, as I understand it, does not fall in that list. So they're just literally making things up. If FOIA law in Iowa works the way that I understand it to work elsewhere, then it should be a pretty well slam dunk case for the ACLU. But I could envision them saying, well, we're going to invoke executive privilege whenever we feel like it for the purpose of making this, basically forcing this law to be a thing.
Well, with the report from the Iowa Office of Civil Rights, they offered us the opportunity for mediation on settlement negotiations with the DAS and the governor's office. And I was just wondering what everybody's thoughts on that are. I don't know. I don't think we'd be asking for too much if we were going to do that, but I do think, in relative terms. But I feel like when somebody like Adam Steen has already hinged his entire identity as being the Jesus guy, and that's his own quote. He put himself out there when he started running for governor as the Jesus guy. He wanted to be known as the Jesus guy. And he's made this his entire campaign, like I said. So it would seem that any concession on his part would potentially collapse his gubernatorial run. What else does he have then at that point? And, to that end, is there a point to going into settlement negotiations? I don't know, but maybe there is. Maybe that demonstrates something to the court if this were to go to court about how we've tried to be reasonable and how, there's just no accommodating us on anything. We could ask for simply an admission that that there was no reason to believe we intended on beating children, and the assurance that we'd be treated like on equal terms with other religious groups going forward. And I feel like that to them that would be far too much. Would there be any point to going into that settlement? Is there any thoughts? I know the ACLU is handling this on our behalf, so we'll let them strategize, but I'm still wondering if you feel it worth offering any commentary on the potential for settlement talks.
I think at this stage, the likelihood of them giving us anything by agreement, which is to say through a mediation, is zero or functionally zero. I have done a lot of these kinds of cases at this point, and the uniform answer is always, oh, it's too early, we can't talk about it. And then after their, bullshit testimony goes down, and then essentially they've put the judge in a position where they have to call one of the witnesses a liar. Then it's, oh, well, you just don't have anything, so we're going to tell you no now too. So my view on these kinds of cases is you either win all or you take nothing.
But winning all for us, I don't think that's asking very much. When we're asking to be treated on equal terms to other religious groups that are already conducting these activities. And that's another thing. They changed the rules several times, and that's part of the complaint. Mortimer and his congregation were going to do Paradise Lost reading, I believe, on the Capitol steps, and it was a multi-day event. And then the state declared suddenly that, and I think they applied the rules retroactively, correct me if I'm wrong, they changed it and to say you could only do one event per year or something like that. But then they carried on allowing some Catholic group to do multi-day events and other such things in a clearly discriminatory fashion. Is that correct? Is that accurate? And is that still happening?
That it's my understanding that they did change the rules, that the rules were changed to be retroactively applicable to our pre-existing application. I don't remember the exact timeline, but it was like beginning of the month or so, the application is made. Toward the end of the month, like a day or two before they told us this is going to apply to you, they essentially changed it. So 1 day per event, per year, per group.
Well, how is it appropriate to retroactively apply something like this? In typical cases, it isn't. Is it only because they hadn't approved or denied the application yet? Was it the idea that the application was still in process, therefore a change in rules was going to affect pending applications?
I mean, I don't perceive a legally valid basis to say we're going to change the rules on the one hand, but on the other hand, I also don't know what the rule procedure is. So, if we change the facts ever so slightly and say it's a like federal government regulatory agencies regulations, there's like a notice period, there's a comment period, there's, I don't want to call them due process protections exactly, but there's some kind of procedural requirements involved. So I don't know if that applies to these or if it's just basically whatever whim-based bullshit some government actor chooses to cook up. And then, if you're bringing, for example, equal protection claim on it, then it's on the judges to come up with any reasonable excuse why that should fly. So it's one of those very gray areas that I can't really say it's definitively permissible or impermissible, but it sure as hell stinks.
Well, my understanding was that they still had religious groups doing multi-day events, Christian religious groups, and that the excuse we got back was that, well, these aren't official events, they're just coming and doing them. And in different circumstances, I would suggest, well, then we should do the same thing. And then, because I feel like if our Iowa congregation were to do the same thing, assuming that it's not a scheduled thing and they just show up, you'd probably get beaten and arrested. And that's why I don't recommend doing it, because we wouldn't want to put you through that hassle and we wouldn't want anybody to have to spend the night in the can or anything like that. And it's not out of the question that that's exactly what would go down, And I feel like that's one of those things where it's like people don't realize the full burden of on the minority end of being a non-preferred religious voice in those scenarios. But do I have that correct, Mortimer? Or do you know of other multi-day religious groups still using the Capitol grounds?
There is a monthly rosary held on the Capitol steps by the Diocese of Des Moines, yes. They just don't have to fill out an application.
Okay, I guess that's just one of those things we have to let slide in the name of safety. But
No,
it is worth mentioning, I think, just because I feel like sometimes we press these cases on the direct evidence we have and things like that, but it doesn't give a full scope of the complete background in, what it means to be on on the wrong side of preferred status. But what are we waiting for next? Like, well, how does this process play out? I know it was said that if it gets towards the 2 year mark, we could go to we may or may not go to federal court. But assuming it doesn't play out that way and we get another response from the Iowa Office of Civil Rights, what does that look like? Do we know?
Well, we won't necessarily get a negative response, and that like it'll be a binding decision that says we lose. Um, it's certainly not as to our federal claim. It would very likely be used against us in court, and I'd fight like hell to say, well, you can't consider that because it's not res judicata, so that's the end of it. But it would certainly not be good for us. Likewise, the corollary is true is if they give us some very useful findings of fact, I think that the other side is going to be jumping up and down and say, well, judge, you can't consider those same arguments. But what we can get is useful admissions. So that's why I want to see that it keeps in here, if obviously consistent with the ACLU's guidance. I do want to make a point though on this notion of the diocese of Des Moines don't have to issue an application. That may be because the whatever government actors are not enforcing the requirement, but it's my understanding that all uses of the state capitol for any kind of an event is subject to the oversight. I mean, that's the whole point of having applications.
Right. Yeah. Yeah, but that I think I don't think that's any part of our complaint though.
No, it is. They're comparators.
Oh, okay.
So it's us saying, hey, look, you know what? They want to change that rule, whatever. That's something that arguably they can do. We're not going to pick that fight, but they're not equally applying that rule to us versus other people, which is a claim in and of itself, but also it has a tendency to prove pretext as to why they weren't letting in our event on this other matter.
That's why in when people ask what they can do in these situations of, whether it's a public prayer or a holiday display or what have you, it's so important to follow the exact rules, because if we give them any reason to deny us, they're going to deny us. So what's left is a pretext. And that's where we have a case. That's where we have an issue. If we followed all the rules, then there's no other explanation as to our denial other than our viewpoint. So yeah, it's exactly that. They're allowed to change the rules, but when they do it retroactively, that is the evidence, partial evidence of the pretext that we can glean from that.
When we run into situations like this with these, some of these denials, I often think that the politicians involved are either lying about what they think the law is or what their responsibilities are, or that they're completely ignorant, that they're just egregiously stupid, and that they have no understanding of what the job is to begin with. And this is one of those where the question is really, really perplexing, because I feel like they could have gone about this so much better if they did actually understand the law. I see so much commentary about us where it seems that litigation is expected from us when it comes to these things, when we issue a denial. And oftentimes you'll see the politicians grandstanding about how it's worth fighting that fight for our religious liberty and our religious viewpoint, and to stand up for Jesus and stand up for godliness in the public square and that type of thing, which is just to say that they're willing to launch a crusade using public funds because there's little to no consequence to them. And clearly a guy like Adam Steen thinks it's going to be all benefit, and he's going to be able to ride that all the way into the governor's office. I mean, maybe I'm asking you to speculate too far, Mortimer, but do you think this guy is as dumb as he appears in his press conferences and in his public statements? Is he that oblivious as to what the actual law is and what the value of religious liberty is and what those things even mean to begin with?
Well, clearly he doesn't understand the process, because he's falsely claimed that we're already suing him. many times. In fact, that's basically his catchphrase. I'm the guy that's being sued by the Satanists. We have
Right,
not.
and it's not a lawsuit. Yeah. This thing with the Iowa Office of Civil Rights is not. It's not elevated to a lawsuit yet.
So he clearly doesn't understand the process. As for his intelligence, I don't know. It could be a good grift. That
I don't.
that's
I
that's
don't
all I
think they
can.
care. I don't think they care. That's what I think it comes down to. I think this is just pandering. When your identity is the Jesus guy, what you're saying is, I don't give a shit about facts. I don't give a shit about evidence. I don't give a shit about the rules, or I don't give a shit about the Constitution. I'm the Jesus guy, so I'm going to do the Jesus guy
And
thing. It's just
they
pandering.
don't give a shit about paying taxpayer money to fight a losing battle.
It's not their money. They're playing with other people's money, and he can still be the Jesus guy. I mean, this whole thread, this whole system of letting these theocrats in government leads to this bullshit. This is the end game of it. Is these are Constitution un-American Jesus guys. That's their whole shtick.
Yeah. We got a question in that says, what can Iowans do to help support this investigation? Can TST members outside of Iowa do anything to help? I don't think additional Freedom of Information Act requests are going to help. That litigation is still pending. I don't know that there's much more to investigate even either, because according to the Iowa Office of Civil Rights, as I said, they've declared that we've made a prima facie case in our favor, that the facts as we state them, if taken as true and uncontested, indicate that we indeed did suffer discrimination at the hands of the Iowa DAS and the Iowa Office of Governor. So that's saying we have all the case we need. And I mean, again, you work on this complaint with us, of course, been lawyers, and we know the facts are as they are, and they can't dispute them as such. I don't know to what degree the governor's office and Adam Steen are free to amend their defense and make new claims in their favor, and how much more favorable that could potentially make that to them. But I mean, maybe you guys have some idea of that. But I think there's no value in writing to the public representatives and just letting them know your viewpoint, letting them know that, you either support us, or even if you don't necessarily support us, you see the value in having government viewpoint neutrality and not allowing government functionaries to decide based on nothing other than their own personal will that they are going to dictate which religions are accepted and which ones are not. I think I just really think that if you're really going to be willing to give up those fundamental freedoms, there should really be a good reason for it. And having a display that says Happy Holidays from the Satanic Temple, or something as innocuous as that, certainly does not rise to those emergency levels of national security demanding the undermining of our entire constitutional foundation. But anyways, the idea that they can change their their defense is how much latitude do they have for that? Have they submitted their idea that we were going to beat children, and the idea that because they denied other applications that were not even 30 days out from the event, are they bound to those now, or are they free to enter new claims as to what their rationale was, if not new evidence?
I don't know how strictly bound they are, but it's another one of those things where it's like if they start changing their story midstream, that's going to be a problem for them. So they're kind of stuck with it. Not like legally there's a rule that says you must be having a consistent narrative, but when you have an inconsistent narrative, it's gonna make for a pretty bad time in court.
We had bad times in court, though, and we look at something like this and we say, how could we lose? But
Oh,
So,
indeed.
so I'll ask the lawyers, how do you think we can lose this one?
Stu, I'm
Heckler's
always the optimist. I'll let you go.
Heckler's veto. This is it always comes down to the heckler's veto. I mean, this is,
Yeah, but a
it's
judge isn't going
unpopular.
to say, you know what, I'm standing by Heckler's veto. Heckler's veto is like explicitly not allowed. It's not a legitimate
Oh,
means in court to deny somebody's rights. I'm talking about, say we go to federal court and a judge decides, you know what, fuck the Satanic Temple just because.
well, is it the whole concept of tradition? The heckler's veto, when we lose on a invocation case, because the tradition is that this has happened since the beginning of the nation. I mean, isn't that the heckler's veto in effect? It's just a longer standing one. In this particular case, it's so ridiculous. Like I'm loving this pretext because it's so ridiculous that I do have a hard time seeing how we lose this one. It's of course we made a prima facie case that if these facts are true, which we know them to be true, I don't think they're in dispute of how this went down. But this one is hard to see how we lose. That's true because these guys followed all the rules, and even when they offered to change the problematic issue, the perceived problem, there was no response. So yeah, I agree with you. How do we lose, Matt? How do we lose this one?
And what,
I don't
and
know,
maybe
actually.
you don't, okay, maybe you don't have an answer for that one, but,
Well,
and how do they, how, what are the consequences? What are the potential consequences, like high end and low end, for the governor's office and the DAS? Should they
well,
care?
I mean, I think it depends on what venue we're in. If we're in admin court, they have to let us in, and they presumably would be administratively barred from denying us on like circumstances into the future. If we're in federal court, that plus a very public order that goes in our favor and order for attorney's fees. So there's very significant upswing if we are in federal court.
Yeah, but
What
the
I hope
bullshit about that is then that the attorney's fees are paid for by taxpayer funds, and I think that's an outrage.
It's outrageous, yes, but that's the way our glorious system works. Why stop the government waste when it comes to attorney's fees for civil rights violations?
Honestly, I think there should be legislation when something is egregiously unconstitutional like this and it runs against the grain of civil rights as any reasonable person would understand it. The public functionary responsible should have to foot the fucking bill.
I
That's
just
a
hope it's only going to take a few of these, and this has been my hope the entire time. Where we have to create a deterrent where when they see what happens when we bring a lawsuit, they're going to go, I'm going to lose my seat, whatever position it is with the public, when I spend $2 million on their money preventing a fucking holiday display. Eventually they're going to wisen up to that. But the problem is the thing that I keep saying is that this hypocrisy, this idiocy has become completely normalized. So that's why they keep doing it.
Well, yeah, I mean, but if there were any consequence uh, to the people responsible themselves, I Adam Steen doesn't really strike me as a genuine hard ass, but it's really easy to try to pretend you're a hard ass when you feel like there's no consequences to you. I mean, it's the coward's glory, and Steen is just lapping it up right now. And he does strike me as potentially a coward enough to be cowed by by just the initial findings of the Iowa Office of Civil Rights, which is what makes me speculate about what becomes of his gubernatorial campaign after this. But I guess all we can do is wait and see. Uh, Mortimer, do you want to give anybody a sense of how to reach out to your congregation if they're local and want to help with you guys, or are you guys staying a little more low key than that at this moment?
Well, we do have our Facebook group, the Iowa Allies and Applicants group. I mean, also this coming Sunday, we're actually still having a holiday event but we're having to move it to a private venue. So you can come out and see us. Ninth Circle, based on the Dante's Inferno, the Ninth Circle of Hell, the frozen ice wasteland. We'll have some goth music. Come out, dance, hang out with us. We're still having a Krampus costume contest. It'll be from 6 to 10. From 6 to 8, we will have it'll be all ages. We'll have coloring pages just like we were going to have at the Capitol. We'll have an ornament making station. So if you want to get to know us, come out and meet us.
So this is at a private venue?
Yes, XBK is a private venue. So unfortunately, we did have to move to a private venue. Yeah.
Oh, so people can come see the controversial event that was banned from
Yes.
public spaces.
See the holiday displays banned from the Capitol building for themselves with their very own eyes.
All this salacious stuff. Like it's okay. I don't know. I don't know if they'll be disappointed if they're expecting something that was worthy of being banned. But it should be fun.
Yeah. Yeah. Have goth dance floor. We got a lot of fun plans for it.
Is it a later night event now for an older audience, or you feel like you're still going to have children presents just in case somebody catches the spirit of Krampus?
We'll from 6 p.m. Central Time to 8 p.m. it'll be all ages, and then after 8 p.m. it'll be 21 plus.
All right.
So,
well, sounds fun. I'm sure we'll be talking about this all at a later date when it progresses further. I thank you all for chatting with me again, and this has been another legal update. Thank you. Hail Satan. Good night.